My guests for this discussion are Imran Ahmed, a partner at Norton Rose Fulbright, and Sean Lynch, Director of Client Strategy for Ricoh Canada. So welcome, Imran.
Thanks for having me, Jim. Looking forward to the conversation.
And welcome, Sean.
Thanks for having me, Jim. Looking forward to it as well.
So let's start with this. And why do business people and IT people, and even lawyers, if they aren't practicing in privacy and security, why do they need to know or care about all this? The question is, isn't that just for specialists like you guys? Do we have to know more than legislation even? Sean?
I'm not sure we necessarily need to know more than legislation, but I think the reason why managing data is so important in the current in legal and professional landscape is because essentially it comes down to managing risk. There is tremendous reputational risk, financial risk associated with poorly managing your data. And I think that's the reason why data management, information governance, legislation as well, kind of spans the entire of business and the legal environment at the moment. There's been a significant uptick recently in the number of ransomware attacks and cyber attacks that organizations have suffered. And as I said earlier, there is significant reputational and financial risk that is associated with any sort of breach of that nature. So it's important for all members of an organization to be mindful of how they're managing their data, how they're storing their data, how they're collecting their data, because it does have a direct impact overall in the long run on, again, that financial and reputational risk for the corporation.
Imran, you might want to jump in. Is the security and the legal obligations go even beyond the legislation, especially if you're a lawyer, right?
Yeah, no, that's exactly right, Jim. So, what's interesting is every organization around the world is now a data company. They consider themselves as being collecting data or being a technology company. Data is really the oil that keeps things going. So even an auto parts manufacturer or a law firm, they all are collecting data, different types of data. And that's exactly your point, right? When we talk about privacy legislation, that's personal information to an individual, could be employee information or otherwise. But when you're working at a law firm, small or large, doesn't really matter. You're going to collect information about your staff for sure, but also your client's information. Some of it is confidential, could be industrial designs. It could be personal information, HR related information. So the big challenge I'm seeing amongst clients is a realization we have a lot of data. Two, how do we sort that data? How do I distinguish between personal information? What are my responsibilities versus those that belong to my client, for example? So we're seeing a lot more contracting between law firms, for example, and their clients, where the clients are saying, I'm going to give you this information, but I want to make sure you're securing it right, that you've got the most cutting edge information, technology, security in place, so that at the end of the day, I'm comfortable. Sometimes that adds a bit more complexity to the relationship, secure portals, secure emails, so on and so forth. And in other cases, when it's actually neglected or not paid attention to, you can have, like Sean was mentioning, cyber attacks that would render that information more public. And then you have the fallout from that as well.
Let's talk a little bit about the legislative framework in Canada. I think the framework is changing, right?
So I think when I speak to clients and when I speak to younger lawyers who are looking to develop a practice in privacy law, one of the things I tell them, it's probably the most exciting time to be in this space because it's the first time in 20 years you're getting a full wholesale change of privacy legislation in Canada. Canada globally recognized that it has to update its legislation. So it all really started with the Europeans when they adopted GDPR. It also followed what the Americans did with 50 states having 50 data breach legislation. And Canada found itself in an odd situation where it was a bit behind the curve. For the listeners here, it may be interesting to know that Canada doesn't have one single privacy law. We have 24 different privacy and data protection laws, which is a reflection of our federal mosaic, if you want to call it that, patchwork of laws.
It's the Canadian way.
It's absolutely the Canadian way, proudly Canadian way. But our legislations, both federal and provincial, some of them are federal for public sector, for private sector, healthcare and industry, some are provincial. So you can see how the complexity in those pieces of legislation and how they operate with one another can change quite a bit. But Canada had been built on an ombudsman model. So this really flows from the 1990s when you had e-commerce businesses pop up for the first time. We're being asked as consumers to provide credit card information. So they adopted a code of conduct. That code of conduct actually became our federal legislation. So in early 2000, when PIPEDA, the federal statute for private sector, kicked in, the model was not one of a harsh enforcement, It was more of an ombudsman one. So try to find an amicable kind of solution if you're offside. We're changing that. So Quebec adopted Bill 64, which is now known as Law 25, which for the first time imposes very significant fines, percentage global turnover if you get it wrong, if you are offside. If you look more to the West and what's happening federally, C-27, the other bill that you mentioned, is the federal bill that was tabled back in June. Same model. If you are offside, you can have significant fines for non-compliance. And it also has a right of private action. So you go to a tribunal. So the risk for an organization to get privacy wrong is significant. You don't have to necessarily go to court. You can go to a specialized tribunal where access to justice arguably is going to be easier for the complainant. Ontario, which currently does not have a private sector piece of legislation, is looking to adopt one. They went through a consultation process. They're watching what's happening in Quebec and how it's implemented. They're looking at what the federal government is doing. So they're probably going to be introducing a new piece of legislation. And further west, Alberta and British Columbia in particular, is looking at modernizing its privacy law. So across the board in the country, you're seeing huge change.
The other question I had was on the penalties, and that I think and this is something where you might say Canada's legislation is getting serious. The penalties before were not anything like they were in Europe or around the world, and they've gotten pretty stiff. Is that carrying on through all the legislation that you see?
Yeah, no, it's a great question. And I'm going to editorialize with my personal view here. I think Canada's current legislation as it stands prior to the Quebec bill being proposed lacked any teeth. As a result, you had to make best efforts, and you always had the opportunity to go back to the commissioner and try to find a resolution and so on and so forth. Now you've got real teeth. When you're talking about a percentage, even if it's as high as 5% of your global turnover, for many organizations, that's going to be a significant number. Where it moves from a nice to have best practice to a pure compliance requirement. So they got to comply, otherwise the penalties are potentially very, very significant. Now, what's interesting is the European legislation is much more restrictive. It is by far, I would say, the gold standard globally. Canada, being a G7 country, but also being a net recipient of foreign direct investment, cannot be too strict or too conservative in its interpretation of privacy legislation. So they had to strike a balance between what the Europeans were doing and what would really fly in the Canadian marketplace without losing any kind of Canadian distinctiveness.
Yeah, one of the things that I picked up is there was some new American legislation that said you had to report in 7 days on a breach. We'll talk about breaches later, but some of these deadlines are really killers in some of the legislation. Is Canada going to keep that type of strict deadline type of approach?
I think the Americans are in many ways ahead of the curve, but they also have a very complex regulatory environment. So for example, the Securities and Exchange Commission, the SEC, has come out with proposed rules on disclosure of post-incident. You have CISA, which is the Critical Infrastructure Securities Agency, that has put out that if you are going to pay a ransom, if you've been victim of a ransomware attack, within X number of hours, you need to report back. So what we have seen is Canada being heavily integrated with the US at every level. It could be auto part manufacturing, for example, we're heavily integrated. Our energy companies are heavily integrated, financial services and so on, without going through the whole list, heavily integrated. So for the Americans, we're a potential risk. And as a result, they've been talking to the Canadian government saying you need to beef up your legislation, not just in privacy, but in security, more broadly speaking. So C-26 is a bill that mirrors what CISA requirements are. In finance, if you look at that industry, for example, OSFI, Office of Superintendent of Financial Institutions, HIROC, and others, the regulatory regime in Canada, depending on the industries that you're in, is becoming more and more complex. And for our audience, who are law firms in some cases, for them, it's even more critical because their clients may be operating in those industries. And as a supplier of services, even if it's legal services, if you have a breach, if you have a privacy incident or a security breach, you may have to report this up to your client, and the client will then be subject to those regulatory requirements.
So one last question, then I'm going to turn it over to Sean for some comments in there, but I just want to ask you just one more question. I'm pretty good at this stuff, but even I get confused about when foreign legislation applies to me, or even when legislation in Canada applies to me. Is there any sort of general idea that you could give people to at least help them sort that out?
Yeah, it's a great question. And there's so many pieces of legislation around the world, sometimes hard to keep track to which one actually applies or doesn't apply. The fundamental piece in law is nexus. You have to have a link to the jurisdiction. typically it's where you are domiciled, not citizenship, not residency, but really where are you domiciled. So if, for example, you are based in Europe for whatever period of time and you go to a hotel and you give your information, including your passport to validate who you are, and then you move back to Canada and that hotel chain has a breach with your information, you would be entitled to say under European law, you should have notified me, so on and so forth.
Wow. And Sean, you're trying to develop corporate strategy and to help clients of Ricoh in this case. Has your life gotten more complicated?
I would say that our clients' lives have gotten more complicated. I don't think that our approach or the advice that we give clients, broadly speaking, has really changed. It has certainly evolved in the last 5 years as the consequences have grown, and the advisory services we provide around information governance, data management, data analysis have risen to the challenge of the pressure that organizations are under. But I think broadly speaking, our position hasn't really changed, which is that you need to know what data you have, you need to know where it resides, and you need to know how that data is accessed and who has access to it. So the principles around information governance and data management haven't changed. I think that, in building on what Imran said earlier, that kind of a corollary to the concerns around what legislation might apply, depending on where you're domiciled, there's also a question about what happens if certain information, just to kind of add some interest and complexity to this even further, there's a question around what happens if information crosses a border when it isn't supposed to. If the information crosses, for example, the Canadian to US border, have you vitiated maybe privilege that's been associated with that information? If it goes to a jurisdiction, for example, like Germany, where they don't have the same conception of privilege protections, it's very complex for clients and for organizations that are involved in international legal disputes. It becomes complicated when you're an international law firm that might be exchanging information to support litigation in multiple jurisdictions. So there's a lot of reasons why you want to make sure as an organization, as a law firm, as a corporation, whomever you might be, that you really do have your handle on where your data is, where it resides, where it's domiciled, as Imran mentioned earlier, and who has access to it from which jurisdiction. So it gets very complex very quickly because that access component can really matter, especially when you're dealing with international litigation.
And you must see this in your dealings with clients. I'm not going to ask you to talk about an individual company or anything like that, Sean, but the companies don't do this very well. I mean, and I will say that just as an IT person, knowing what our data is really a challenge.
Yeah, it's a challenge because it's so vast. And developing a policy, even with the general principles in place, developing a policy that's applicable to all the different components of an organization is quite challenging. Data in and of itself is incredibly valuable to organizations. It is something that they base their marketing on, their product development. Everything that involves their business is now linked to the data that they hold. So controlling where that data is and who has access to it limits the ability of an organization to expand its product base, expand its consumer base. It is a competing interest between the desire of the legislative framework and of individuals to ensure that their private information is protected and not accessed against the desire and need to an extent of an organization to better serve its consumers. So it gets very complex, and those two things kind of rub each other the wrong way on occasion. And we need to be mindful as we're going into this complete field of data that we have, that we're using it for the right purposes and we're allowing access for the right reasons.
I just wanted to build on a great point that Sean was mentioning about the collection of data. I mean, we're talking a lot about legislative changes and privacy law, and that's certainly very important. I don't want to minimize that. But one thing we forget about often, and especially law firms when they're dealing with clients, there are contracts. Contract will stipulate unique provisions. So for example, you may be a law firm that's advising a company doing business with the government of Canada or in your province. And the government, because a particular department or crown corporation may say you cannot take the data outside of the country. You can't only not take the data out of the country, you cannot take the metadata out of the country. So if you get breached and you need to do a doc review, for example, what Sean and his team would be doing, you got to make sure that the servers are located in Canada, and potentially in some cases, the reviewers are based in Canada as well. And in a crisis scenario, especially when you're looking at a cybersecurity incident, like a ransomware attack where everything is encrypted, you mentioned about blank stares. Sometimes clients like, I think I have an agreement with the bank. I think I have an agreement with a client, but I'm not sure if it says suspected incident or breach or actual data theft. So we've talked a lot about legislation, and that's fantastic. And I think people should be mindful of it. But the contractual piece, the one that gives the most headaches when we're dealing with these situations.
Yeah, I think that's an incredibly good point. And certainly when it comes to RICO and addressing contractual issues and contractual negotiations with our clients, this exact issue comes up on a regular basis. If you're subcontracting, where are your contractors going to be based? Where are your servers based? What is an SLA with respect to not necessarily if there's a breach, but if there's the potential of information that is left where it's supposed to be? Can you have non-Canadians access data that is physically resident in Canada? It is on a Canadian server, but are you permitted to allow an individual outside of Canada to access it and to view it? And there's a question as to whether or not viewing a document constitutes the document and the information leaving a certain jurisdiction. And that's still kind of a gray area, and we're not really sure where that's going to go. But these are the kind of the questions that we're faced with on a regular basis from a contractual perspective. Same thing when it comes to security. What security provisions are in place? What security are you utilizing to ensure that data is not going to get breached? And I think that the level of complexity has not really been appreciated yet by organizations around the world. I think maybe some European corporations are, because they've been steeped in GDPR for a little bit longer, they're a bit more mindful of it, and they've kind of internalized it in a way that North American corporations really haven't. So the organizations, I think, are going to be in for a kind of a surprise, a shock perhaps, when they really start getting confronted with challenges that are born of this legislation. The ease of access through a tribunal rather than needing to go through a court means that organizations are going to be faced with these challenges on a regular basis, much more so than they are now. And I think that's really going to affect the way that they structure their data, the types of data they're willing to collect, how frequently they delete their data. Because again, there is that value, as I was discussing earlier, in the data in and of itself. It's a very valuable component to an organization's overall business strategy, but the risk associated with holding it might get to the point where it tips toward the need to delete it quickly rather than hold on to it.
There's the other piece about data retention as well that falls under governance. And, Sean mentioned this, but just to give you an example, law firms, one of the first things lawyers have to do with their clients, especially if you're working directly with an individual client, not just corporations, is know your client, KYC. One of the most common ways of doing a KYC is getting somebody's passport, driver's license to validate, legitimately who they are. If they are indeed Imran Ahmad, located at whatever 1 Main Street in whatever city. But you'd be shocked how some law firms do this. They'll be collecting it by email. Email is stored for years on end. And the moment the mailbox gets compromised, all of a sudden you've got years and years and years of KYC information, which is the most sensitive information you have on a person to conduct identity fraud by hackers, is out there. So the purging of the data, making sure you actually retain what you need and knowing what kind of data you're collecting, especially in an unstructured data set like emails, can be a key issue to consider. Easier to get it done before the breach occurs than when you're doing it when a breach occurs itself.
Imran is exactly right. The active management of the data you're holding is, I think, going to become the most important component of overall information governance. We're not going to want to be in a situation where we're holding anything that we don't need to hold or that we shouldn't be holding. With Imran's example, with KYC, under the rules essentially with the Law Society of Ontario, and certainly from my knowledge base, the Law Society of Ontario, you're required to know that your client is the person who they say they are, which makes sense, as Imran said. But after you know who they are, why do you need to hold that data? If you have an internal structure that says, yes, we verified this person is who they say they are, why do you need the actual data that helped you identify them? And that's the mindset that we really need to be in from an organizational perspective. And there are going to be instances, I think, where different regulatory frameworks kind of butt heads here, where from a risk perspective, I don't want to hold on to this anymore, but there's a regulatory framework that says I have to. And I think that that's going to be something that we're going to see causing friction or significant friction in that regulatory environment.
Sean made such a critical point. I just wanted to flag it for the audience. He mentioned the term active management. That is critical. There were times 20 years ago when you actually had folders and banker boxes where you would have some consultant come in and clean it up and put it into an iron box or Iron Mountain storage facility. But now you need to have an active management. You have to have a protocol. And, I hope we're going to talk a little bit about technology, because I know Sean has a lot to share on that piece. But with the advent of machine learning, AI, algorithms, really working on one hand with the legal requirements, contractual, legislative, and so on, law society related as well, in conjunction with the technology piece that Rico and Sean's team do, is the new norm from what I can tell. Clients are saying we got to bring both the operational and the legal together.
Yeah, I think we're all curious about how you actually handle this in there. And technology created the problem. Can technology assist us in addressing the problem is the question. Sean, do you want to just jump in at first in there? Or Imran?
Absolutely. I think that the technology is definitely the solution here. We have artificial intelligence, machine learning, tools that make this process significantly easier than it ever has been before. So there are different types of data that we as organizations hold and that we utilize on a daily basis. What we're really looking for is, where is the data held and who has access to it? So data analysis can tell you that information. Where is the data held? Is it on a server? Is it in the cloud? What is that data? Is it personally identifying information? Is it someone's passport? Is it credit card information? Is it canceled checks? All of these things that lend a concern to the data being held in the first place. So technology is able to do that. We can use pieces of technology that crawl over entire networks, identify the type of information that's there, tell a user when was the last time it was accessed. Because if something was accessed 20 years ago, what's the value of holding it if you haven't touched it in 20 years? What we're really looking for when we run these types of data analysis projects is we're looking for ROT. And ROT stands for redundant, obsolete, or trivial data. Redundant being multiple copies of the same thing, obsolete being that data that you haven't touched or used in years, or trivial, information that may contain personally identifying information, but why would you be holding on to this anyway? A birthday party invitation, which is something we use in the industry all the time. Like, is that something you really need to hold on to? No, but does it have a lot of information in it? Yeah, it does. It'll talk about who was at a party, when were they there, what time were they there, who are they going with, perhaps. There's a lot of information contained in things that are really trivial that we don't need to hold on to. There are tools now that we can use to essentially suss data as it comes in and determine whether or not it's information we need to hold on to or should be deleted. If anyone uses Focused Inbox in the Outlook app, for example, that is a tool that we use to identify information that's likely important and kind of shove everything else off to the side. And that's where robust information governance policies come in. It's where access policies come in. And it's where, as Imran mentioned earlier, it's where the data retention policies come in. How long do you really want to hold on to something? And what the industry, I think, is going to have to get very used to, and as a lawyer myself, and I'm sure Imran has an issue with this, deleting data is kind of an uncomfortable situation to be in. No one really likes doing it, but you have to. We've come across this in organizations where they're going through what we call a lift and shift process. So lots of organizations want to move to the cloud at the moment because it's less expensive, it's more robust. The security's better, it's harder to access than to have a hardline server in your organization. But one of the greatest issues with that is IT doesn't want to move everything that's there because it's expensive and time consuming. They don't want to lift and shift everything to the cloud. Whereas some other parts of the organization, sales, legal, might want to say, well, we really should keep everything we possibly can because we don't know if we're going to need it in the future. And that's the mindset we're going to have to break. All that it's doing is creating a risk for you and your organization if you're holding onto it and you don't need it.
So Sean, you got to be watching things like AI and tool sets like that that help make this problem more automatable, if that's a word.
All of our problems are not going to be solved by AI. There needs to be a human element that looks at data, that determines whether or not for an organization it's valuable or risky. But you certainly can program and teach artificial intelligence tools to do a really good job of sorting that information for you, to reduce the workload on the organization, to reduce the risk, and to delete things as they come in that you don't need. I'm sure everyone who's watching this has a spam folder that has 27,000 emails in it. We all collect all sorts of junk, and we don't think about it because it's so trivial. And that's the thing that we need to turn our minds to, I think, organizationally. We have to realize that there's a lot of stuff that comes in. Just because it comes to us doesn't mean it has any value.
There's a lot to do. What are the first steps we should be taking?
The first step is to find out what you have and where it is. That's the most important thing. Because once you know that, you can assess, what can I get rid of right away? And then your data will tell you, what type of information governance policy do I need? Am I holding a lot of contracts in one area that everybody has access to? The types of contracts that I'm holding, do they have different provisions in them with respect to security? Am I even allowed to hold this on a network based on the contract, or do I need to move it somewhere else? That's just one example. But once you have an understanding of what you actually need to hold, from there you can build an information governance policy. From there you can build a breach response strategy if you ever do get breached. And honestly, in the current world, it's not a matter of if you get breached, it's when. And when you get breached, having a breach strategy that's involving an IT provider who can give you answers quickly, you can meet response deadlines required by various pieces of legislation, as Imran was talking about earlier. And then once you have a breach response, how do you deal with a regulatory framework afterwards?
Wow. Last words, guys. Imran, what would you like people to remember from this talk? And this has been a great talk. Thank you so much for doing this. But what should we remember and take away from this?
One of the challenges we have when we broach the topic of data governance, like, it seems daunting, right? Where do we start? How do I get this going? So 3 steps, I won't say simple because they're quite involved. Step 1, identify or get an inventory map of your data. Number 2, once you have that map, pick off and take off what you're going to need and what you don't need. The birthday card example that Sean mentioned. And then 3rd, purge what you don't need, and then just do maintenance on that afterwards. The first time it may be a bit daunting. And yes, there is a bit of an investment in resources, but you're reducing your digital footprint in a meaningful way. You're making yourself have a better cyber hygiene, better data hygiene, and afterwards easier to maintain that as opposed to redoing it every year. One of the biggest mistakes I see small, medium, large law firms making, other clients as well, is they say, okay, I got a budget, I'll do it 1 year, and then I'll wait 5 years to do another cleanup. No, you should really be doing this on a constant basis. It's a cycle.
Great advice. Sean, final words, last message you want people to walk away with from this, and help talk them back off the ledge as well.
Yeah, I agree with everything Imran just said. And yes, it is daunting at the beginning, but the technology is there. There are vendors in the market. There are law firms in the market like Norton Rose that have a tremendous amount of experience around cybersecurity and advice associated with it on information governance that can really help you do a lot of the work that you need to do and get a policy in place that will serve your organization. So I think that it is, again, identifying what you have, determining what you can get rid of, and then persisting with the process you've identified, the governance strategy you've identified, to ensure that your data is managed as best as it possibly can be.
Fabulous. Gentlemen, thank you so much.
Thank you for having me, Jim. Great conversation.
And thank you, Sean.
Thanks very much, Jim. And thanks, Imran, as well. That was great.
Sean, that was a great session with Imran and you, and it gave us a lot to think about. But I got a question for you. We got a lot of concepts and things we need to think about, but to put those in a really concrete perspective, here's the question. In a couple of minutes, could you describe how you would work with a client to get them to be ready to be in compliance or meet the objectives that Imran and you talked about?
Yeah, of course. So the first thing that we do at the start of any engagement is getting an understanding of what a client's footprint might be. And by footprint, I mean, where's their data living? What types of data do they have? Who has access to it? So questions along the lines of, do you have your data stored in a server? Are you in the cloud? How many employees do you have? Do you have offices on either side of a certain border? Are you multi-jurisdictional generally? All of these data points will assist us in guiding a client towards determining what the best structure of their data should be. Most of our engagements are involved with determining the types of data that clients don't need to hold on to. As Imran and I discussed, there's a lot of risk that's associated with not knowing what data you have, and further to that, holding on to data that you don't need. It's important for organizations to recognize that it's better to get a jump start on this now than to wait for regulation to come in place to force you to do it. We can get a pretty good sense now, as Imran discussed, what the regulatory framework is likely to look like in a few years' time in Canada. And we already see across the globe that GDPR from the EU is a fairly guiding principle on where most jurisdictions are going. Getting into compliance with the conceived idea of GDPR and what it might look like in Canada at this stage is a very, very good idea. Not only that, but getting into compliance is almost kind of an afterthought, because the goal of any sort of data analysis engagement with our clients is to ensure that their organization is functioning better, that it's more efficient, that it's more effective, that individuals in the organization know where to go to find certain pieces of information. And knowing where your data is can greatly increase revenue opportunities. It can significantly decrease risk. And it can also make for just let's say, a generally happier workforce if they know where all of the information they need is located. And that's part and parcel of the other component of an engagement with RICO, the development of, for example, a data retention, data destruction, and information governance policies. Lots of organizations have them in place right now, and a lot of organizations are not abiding by them. One part of the engagement with RICO would be to determine, once we understand what your footprint is, ensuring that your organization is actually abiding by its current policy. And if it isn't, why isn't it? Because there might be a good reason for that. And moving past that, if they don't have a good information governance strategy and data retention policy, assisting them with building one, and then getting a process into place for them so that they can ensure that they're in compliance with their own policy, that their policy makes sense for them, and that their policy is, to an extent, future-proof, as the policy has built into it necessary revisiting of the policy and analysis of where data moves around the organization. And by undertaking all of these steps and by working in a consultative approach with our clients, we can help them arrive at a much better and more steady state for the management of their data.
Yeah, if you can't find it, you can't protect it. Mm-hmm. Yeah, that's great. Thank you so much. And if people have questions and want to contact you, how do they do that?
So there are two people. First is me. You can reach me at sean.lynch@rigo.ca. The second person is one of the senior managers in our business development group. Her name is Katie Hegarty, and her email address is katie.hegarty, Hegarty, @rigo.ca. And either one of us would be happy to help.
Thank you very much. Great to have you here.
Thanks.